Hi there. I hope you're keeping well. As we discussed in submodule 8A, OSFI is the agency responsible for the prudential regulation of federally regulated financial institutions. OSFI discharges its responsibilities via 5 core functions. You may also recall that 3 of these 5 core functions comprise supervisory activities. In the context of the prudential supervision of federally regulated insurers, supervisory activities essentially consist of 3 types of assessments. 1. Assessing these insurers' financial position vis-a-vis OSFI's financial expectations, including capital and liquidity expectations. 2. Assessing how well these insurers are doing vis-a-vis OSFI's risk management and control expectations. 3. Assessing how well these insurers are doing vis-a-vis the ICA's requirements. You may also recall that a 4th core OSFI function is to promptly advise the management and board of directors of a federally regulated insurer in the event that the insurer either is not in sound financial condition or is not complying with OSFI's expectations or is not complying with the ICA. This is called intervening or intervention. But as we will discuss a bit later in this submodule, this by no means suggests that intervention is limited to notifying an insurer of an issue. The purpose of this current submodule is to go into more detail about OSFI's supervision and intervention activities than we did in submodule 8A. Specifically, we will examine certain key supervisory and intervention powers granted to OSFI by the ICA. But before we start this deeper dive, I think it's useful to make a general observation. OSFI's supervision and intervention powers provide it with the tools necessary to pursue its objects under the OSFI Act and to strive to protect the rights and interests of policyholders and other creditors of federally regulated insurers. As described in the intervention guides in the required and recommended readings for this submodule, the objective of supervision is to enable OSFI to identify areas of concern at an early stage, which then allows OSFI to intervene effectively, as the case may be, so as to avoid or minimize losses to policyholders and other creditors of federally regulated insurers. Now, let's start by examining some key supervision powers granted to OSFI by the ICA. Supervision activities are generally the way that OSFI becomes aware of an issue. And this awareness, of course, always precedes an intervention measure. Supervision is therefore a key activity in OSFI's day-to-day work. It's absolutely key. Section 674 of the ICA states that for purposes of determining whether a federally regulated insurer is complying with the ICA and is in sound financial condition, the superintendent shall, at least once a year, so again, at least once a year, examine and inquire into the business and affairs of the insurer. Now, in practice, OSFI is in regular contact with all of the financial institutions it regulates, especially those that are medium-sized or large, and those that are at stage 1 or higher rating under the applicable OSFI intervention guide. In addition, Section 664 of the ICA provides that an insurer must provide the superintendent with any information at the times and in the form required by the superintendent. So this is a very broad power. And again, this provision provides that an insurer must provide the superintendent with any information at the time and in the form required by the superintendent. In order to get a better idea of the nature and scope of an actual or possible issue, the superintendent may, under subsections 348.2 or 348.3 of the ICA, require an insurer's external auditor or another auditor to conduct a special examination into that issue and to report its findings to the superintendent. And under subsection 348 sub 4, that special examination is on the insurer's dime. So when in the course of its supervision or other work, OSFI becomes aware of an issue with a financial institution's legislative compliance, financial position, or risk management or controls, then the superintendent can, if appropriate, exercise the intervention powers granted by the ICA. Now, let's turn to these intervention powers. OSFI exercises its intervention powers in accordance with the government's early intervention policy set out in the 1995 White Paper, which was finalized and codified in 1996. This policy is neatly summarized on pages 73 and 74 of the 1999 Policy Paper. And I quote, "In 1996, the government introduced an early intervention policy with three main components. 1. A legislative mandate for OSFI that recognizes the need for prompt action by the supervisor and by the institution to resolve problems. 2. Guides to intervention that make clear to institutions the actions the supervisor will take if the financial condition of an institution deteriorates. 3. The power to close a troubled institution while its capital is still positive. In other words, before it becomes insolvent. The government is committed to the principle of early intervention as a means of preserving the safety and soundness of the financial services sector." End of quote. Before discussing the intervention powers in detail, it should be noted that when the superintendent uses these powers, they do so in a way that is measured against the facts at hand and in accordance with the stages described in the applicable intervention guide. So it's measured against the facts and consistent with the applicable intervention guide. Intervention is therefore a case-by-case exercise based on what is appropriate in the circumstances. There is no one-size-fits-all. It is also an exercise that must generally be conducted in accordance with the principle of procedural fairness. And that includes a financial institution's general right to be heard by OSFI before OSFI decides to exercise its intervention power. Now, let's examine 6 of the superintendent's intervention powers under the ICA. Again, the superintendent strives to exercise these powers in a manner that is appropriate vis-a-vis the facts and in accordance with the intervention guide and the principles of procedural fairness. So first of the 6 intervention powers. This one is provided by subsection 515 sub 3 of the ICA, and it empowers the superintendent to order the insurer to increase its capital or to provide additional liquidity in any forms and amounts that the superintendent may require. It should be noted that this decision applies to the insurer and not to the owner or owners of the insurer. second intervention power that we'll be discussing. So this second power is set out under section 675.1 of the ICA, and it provides the superintendent with the ability to enter into a prudential agreement with an insurer in order to implement any measures designed to maintain or improve the insurer's safety and soundness. Since this intervention power is in the form of an agreement, both the insurer and the superintendent must negotiate it and eventually agree to all of its terms and conditions. Intervention power number 3. If the superintendent is of the opinion that an insurer is committing or is about to commit an act or conduct that is not safe or sound. So again, committing or is about to commit an act or conduct that is not safe or sound, then section 676 of the ICA states that the superintendent may direct the insurer to do any or all of the following. Either cease or refrain from doing the act, or take such steps as, in the opinion of the superintendent, are necessary to remedy the situation. This power under 676 is also often called the power to issue a direction of compliance. Now, where, in the opinion of the superintendent, the delay caused by following procedural fairness may be prejudicial to the public interest, subsection 676 sub 3 allows the superintendent to direct the insurer to take the action or actions for a period of 15 days. Under 676 sub 4, this decision exercised under 676 sub 3 remains in effect after the 15 days if the insurer either makes no representations within that time or has failed to satisfy the superintendent that the representations made are sufficient grounds to revoke the decision. Fourth intervention power. Under subsections 678.4 and 4.1, where an insurer is subject to a capital or liquidity order, a prudential agreement, or a direction of compliance, the superintendent is given another power. And this is the power to disqualify a person from being elected or appointed as a director or senior officer of the insurer. Note, though, that the superintendent's decision must be based on the person's competence, business record, experience, conduct, or character. Fifth power. Regardless of whether an insurer is subject to a capital or liquidity order, a prudential agreement, or a direction of compliance, section 678.2 empowers the superintendent to remove a person from their office as a director or senior officer of the insurer. Again, the superintendent's decision in this case must continue to be based, or must still be based, on the person's competence, business record, experience, conduct, or character. Sixth power. Subsection 679 sub 1 provides the superintendent with the ultimate authority to carry out the endeavor in pursuing OSFI's objects to protect the rights and interests of policyholders and other creditors of federally regulated insurers. Under this subsection, the superintendent may, in circumstances set out under 679 1.1, which we will discuss in a few seconds, do one of the following two things. One, take control for no more than 16 days of the assets of the insurer. Or, unless the minister advises that it is not in the public interest to do so, take control of the assets for more than 16 days, or even take control of the insurer itself. The minister thus has a public interest override of the superintendent's power to take control of an insurer. The circumstances that are set out under 679 1.1 include, among others, the following. The insurer has failed to pay its liabilities, or, in the opinion of the superintendent, will not be able to pay its liabilities as they become due and payable. A second circumstance that is listed under 679 1.1 is that the insurer does not have sufficient assets, in the opinion of the superintendent, to provide adequate protection for its policyholders or other creditors. So it doesn't have sufficient assets to provide adequate protection for its policyholders or other creditors. Another circumstance for taking control: an insurer whose capital has, in the superintendent's opinion, reached a level or is eroding in a way that may be detrimental to its policyholders or creditors. Yet another circumstance for taking control is an insurer who has failed to comply with a capital order. And just to list another example, to list another circumstance, and this is what we call the basket clause or the catch-all, is an insurer that, in the opinion of the superintendent, there are a state of affairs that exists which are likely to be materially prejudicial to the interests of the insurer's policyholders or other creditors. Where the superintendent takes control of the insurer itself. Subsection 683 provides that the powers of the insurer's directors and senior officers effectively pass on to the superintendent. And the superintendent may appoint one or more persons to assist in the management of the insurer. And where the superintendent has taken control of the assets of an insurer for more than 16 days, or where the superintendent has taken control of the insurer itself. Section 684.1 gives the superintendent the discretion to request the Attorney General of Canada to apply for an order from a court under the Federal Winding Up and Restructuring Act, or WURA for short, to wind up and liquidate the insurer or to restructure the insurer. In practice, the superintendent would generally exercise their powers under 679 sub 1 with a view to putting the locks on the doors of the insurer and arrange to make it subject to WURA. So this concludes our examination of the superintendent's intervention powers. To sum up, the ICA provides the superintendent with numerous supervisory and intervention powers, including the power to take control of an insurer that has become or is about to become insolvent. While only one of the intervention powers requires the consent of the insurer, and that's the prudential agreement, the use of almost all of the other intervention powers require the superintendent to respect the principles of procedural fairness, including the right of an insurer to be heard before the superintendent makes a decision. In exercising these powers, the superintendent also strives to exercise them in a manner that is appropriate in the circumstances and that is consistent with the applicable intervention guide. This concludes the recording for Module 10D. Bye for now.